United States v. Mendenhall, Supreme Court, 1980. Justice Stewart announced the judgment of the court. The respondent was brought to trial in the United States District Court for the Eastern District of Michigan on a charge of possessing heroin with intent to distribute it. She moved to suppress the introduction at trial of heroin as evidence against her on the ground that it had been acquired from her through an unconstitutional search and seizure by agents of the Drug Enforcement Agency. The district court denied the respondent's motion, and she was convicted after trial upon stipulated facts. The Court of Appeals reversed, finding the search of the respondent's person to have been unlawful. 1. At the hearing in the trial court on the respondent's motion to suppress, it was established how the heroin she was charged with possessing had been obtained from her. The respondent arrived at the Detroit Metropolitan Airport on a commercial airline flight from Los Angeles early on the morning of February 10, 1976. She disembarked from the airplane. As she disembarked from the airplane, she was observed by 2 agents of the DEA who were present at the airport for the purpose of detecting unlawful traffic in narcotics. After observing the respondent's conduct, which appeared to the agents to be characteristic of persons unlawfully carrying narcotics, the agents approached her as she was walking through the concourse, identified themselves as federal agents, and asked to see her identification and airline ticket. The respondent produced her driver's license, which was in the name of Sylvia Mendenhall, and in answer to a question of one of the agents, stated that she resided at the address appearing on the license. The airline ticket was issued in the name of Annette Ford. When asked why the ticket bore a name different from her own, the respondent stated that she just felt like using that name. In response to a further question, the respondent indicated that she had been in California only 2 days. Agent Anderson then specifically identified himself as a federal narcotics agent and, according to his testimony, the respondent became quite shaken and extremely nervous. She had a hard time speaking. After returning the airline ticket and driver's license to her, Agent Anderson asked the respondent if she would accompany him to the airport DEA office for further questions. She did so, although the record does not indicate a verbal response to the request. The office, which was located up one flight of stairs, about 50 feet from where the respondent had first been approached, consisted of a reception area and joined by 3 other rooms. At the office, the agent asked the respondent if she would allow a search of her person and handbag and told her that she had a right to decline the search if she desired. She responded, "Go ahead." She then handed Agent Anderson her purse, which contained a receipt for an airline ticket that had been issued to F. Bush 3 days earlier for a flight from Pittsburgh through Chicago to Los Angeles. The agent asked whether this was the ticket that she had used for her flight to California, and the respondent stated that it was. A female police officer then arrived to conduct the search of the respondent's person. She asked the agents if the respondent had consented to be searched. The agent said that she had, and the respondent followed the policewoman into a private room. There, the policewoman again asked the respondent if she consented to the search, and the respondent replied that she did. The policewoman explained that the search would require that the respondent remove her clothing. The respondent stated that she had a plane to catch and was assured by the policewoman that if she were carrying no narcotics, there would be no problem. The respondent then began to disrobe without further comment. As the respondent removed her clothing, she took from her undergarments 2 small packages, one of which appeared to contain heroin, and handed both to the policewoman. The agents then arrested the respondent for possessing heroin. It was on the basis of this evidence that the district court denied the respondent's motion to suppress. The court concluded that the agent's conduct in initially approaching the respondent and asking to see her ticket and identification was a permissible investigative stop, finding that the conduct was based on specific and articulable facts that justified a suspicion of criminal activity. The court also found that the respondent had not been placed under arrest or otherwise detained when she was asked to accompany the agents to the DEA office, but had accompanied the agents voluntarily in a spirit of apparent cooperation. It was the court's view that no arrest occurred until after the heroin had been found. Finally, the trial court found that the respondent gave her consent to the search in the DEA office, and such consent was freely and voluntarily given. 2. Here, the government concedes that its agents had neither a warrant nor probable cause to believe that the respondent was carrying narcotics when the agent conducted a search of the respondent's person. It is the government's position, however, that the search was conducted pursuant to the respondent's consent and thus was accepted from the requirements of both a warrant and probable cause. Subpart A. The Fourth Amendment's requirement that searches and seizures be founded upon an objective justification governs all seizures of the person, including seizures that involve only a brief detention short of traditional arrest. Accordingly, if the respondent was seized when the DEA agents approached her on the concourse and asked questions of her, the agent's conduct in doing so was constitutional only if they reasonably suspected the respondent of wrongdoing. But, obviously, not all personal intercourse between policemen and citizens involves seizures of persons. Only when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen may we conclude that a seizure has occurred. We adhere to the view that a person is seized only when, by means of physical force or show of authority, his freedom of movement is restrained. Only when such restraint is imposed is there any foundation whatever for invoking constitutional safeguards. The purpose of the Fourth Amendment is not to eliminate all contact between the police and citizenry, but to prevent arbitrary and oppressive interference by enforcement officials with the privacy and personal security of individuals. As long as the person to whom questions are put remains free to disregard the questions and walk away, there has been no intrusion upon that person's liberty or privacy, as would under the Constitution require some particularized and objective justification. Moreover, characterizing every street encounter between a citizen and the police as a seizure, while not enhancing any interest secured by the Fourth Amendment, would impose wholly unrealistic restrictions upon a wide variety of legitimate law enforcement practices. The court has, on other occasions, referred to the acknowledged need for police questioning as a tool in the effective enforcement of the criminal laws. Without such investigation, those who were innocent might be falsely accused, those who were guilty might wholly escape prosecution, and many crimes would go unsolved. In short, the security of all would be diminished. We conclude that a person has been seized within the meaning of the Fourth Amendment only if, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. Examples of circumstances that might indicate a seizure, even where the person did not attempt to leave, would be the threatening presence of several officers, the display of a weapon by an officer, some physical touching of the person of the citizen, or the use of language or tone of voice indicating that compliance with the officer's request might be compelled. In the absence of some such evidence, otherwise inoffensive contact between a member of the public and the police cannot, as a matter of law, amount to a seizure of that person. On the facts of this case, no seizure of the respondent occurred. The events took place in the public concourse. The agents wore no uniforms and displayed no weapons. They did not summon the respondent to their presence, but instead approached her and identified themselves as federal agents. They requested, but did not demand, to see the respondent's identification and ticket. Such conduct, without more, did not amount to an intrusion upon any constitutionally protected interest. The respondent was not seized simply by reason of the fact that the agents approached her, asked her if she would show them her ticket and identification, and posed to her a few questions. Nor was it enough to establish a seizure that the person asking the questions was a law enforcement official. In short, nothing in the record suggests that the respondent have any objective reason to believe that she was not free to end the conversation in the concourse and proceed on her way. And for that reason, we conclude that the agent's initial approach to her was not a seizure. Our conclusion that no seizure occurred is not affected by the fact that the respondent was not expressly told by the agents that she was free to decline to cooperate with their inquiry, for the voluntariness of her responses does not depend on her having been so informed. We also reject the argument that the only inference to be drawn from the fact that respondent acted in a manner so contrary to her self-interest is that she was compelled to answer the agent's questions. It may happen that a person makes statements to law enforcement officials that he later regrets, but the issue in such cases is not whether the statement was self-protective, but rather it was made voluntarily. Subpart B. Although we have concluded that the initial encounter between the DEA agents and the respondent on the concourse in the Detroit airport did not constitute an unlawful seizure, it is still arguable that the respondent's Fourth Amendment protections were violated when she went from the concourse to the DEA office. Such a violation might in turn infect the subsequent search of the respondent's person. The district court specifically found that the respondent accompanied the agents to the office voluntarily in a spirit of apparent cooperation. The question whether the respondent's consent to accompany the agents was in fact voluntary or was the product of duress or coercion, express or implied, is to be determined by the totality of all the circumstances and is a matter which the government has the burden of proving. On the other hand, it is argued that the incident would reasonably have appeared coercive to the respondent, who is 22 years old and had not graduated from high school. It is additionally suggested that the respondent, a female and a Negro, may have felt unusually threatened by the officers, who were white males. While these factors were not irrelevant, neither were they decisive, and the totality of the evidence in this case was plainly adequate to support the district court's finding that the respondent voluntarily consented to accompany the officers to the DEA office. Subsection C. Because the search of the respondent's person was not preceded by an impermissible seizure of her person, it cannot be contended that her apparent consent to the subsequent search was infected by an unlawful detention. We conclude that the district court's determination that the respondent consented to the search of her person freely and voluntarily was sustained by the evidence, and that the Court of Appeals was, therefore, in error in setting it aside.